Hello and welcome everyone. I hope this message finds you fit and fine. Today we need to talk about high courts in India. Even if you have covered Supreme Court, don't take high court part lightly because there are some differences and UPSC has asked questions from this topic consistently. Let's start with the basics. So high court were introduced in India by Britishers, for example in Calcutta, Bombay and then Madras. In our constitution, high courts are mentioned in part 6 of Indian constitution. Okay, starting from article 214 to 231. Original constitution was saying there will be one high court for one state, but after 7th constitutional amendment act, now there can be one high court for more than 2 states or UTs. It means one state, one UT. Now, can you tell me, can you give some examples of common high courts in comments? So we have integrated judiciary, right? We have Supreme Court, then we have High Court. So today our focus is on High Court. Let's talk about some differences. There can be questions from here. When it comes to Supreme Court, decisions are binding on all courts. All courts means whether High Court or subordinate court, means district court. Can transfer High Court judges? It means we are talking about collegium, in which CJI's role, means Chief Justice of India's role, and Senior Supreme Court judge's role becomes important. Can call a case from lower court to itself, can transfer cases from one high court to another. So these are the powers of Supreme Court. High Court considers appeal from lower court. Appellate jurisdiction, we are going to talk about it today. Has the power to issue fundamental right, means writs and fundamental right. Article 226 deals with cases within its state jurisdiction, means you cannot take up case from other state. What does it mean? If some crime has happened in another state and district court of that state has given some judgment, can you take that particular case as an appeal? No, that particular state's high court is going to take up that. Supervises and controls lower court. We are going to talk about supervisory jurisdiction of high court here. District court deals with local cases of the district, consider appeal regarding lower court decisions, decides serious crime cases. Subordinate court deal with cases of civil and criminal nature. Now, appointment. So judges of high court are appointed by president. Please remember that. They are not appointed by governor. Sometimes UPSC play along these lines. Chief Justice is appointed by president after consultation with CJI and the governor of the state. Although we are going to talk about third judge's case here, then you are going to remember the collegium part. For appointment of other judges, Chief Justice means Chief Justice of that high court need to be consulted. Okay, that's a standard rule you should remember. Okay, for example, if you are a team manager and someone need to be appointed in your team, so this is a standard practice now. You are going to be consulted because any judge of a high court has to work in close coordination with the CJ of that high court, Chief Justice of the high court. Chief Justice of High Court is going to decide which kind of cases, what case is going to be taken up by this particular judge, okay, this particular bench. In case of common high court of 2 or more states, the governors of all states concerned are consulted by the president. In second judge's case, Supreme Court ruled that no appointment of judge of the High Court can be made unless it is in conformity with the opinion of Chief Justice of India. Then it was later elaborated, third judge's case, collegium. Supreme Court opined that in case of appointment of High Court judges, the Chief Justice of India should consult a collegium of 2 senior most judges of Supreme Court. This is what third judge's case was saying in 1998. It means 1 CJI and 2 senior most judges. The sole opinion of CJI is not going to be considered, right? Consultation means you have to consult 2 senior most judges in case of appointment of high court judges. Okay, there can be a question from here. 99th constitutional amendment came and there was a body NJAC which government tried to make, National Judicial Appointment Commission. We discussed this in Supreme Court chapter also. But what happened? In 4th judge's case 2015, Supreme Court has declared both the 99th Constitutional Amendment Act, which was creating NJAC, as well as NJAC Act as unconstitutional and void. Why? Because Supreme Court said it is going to compromise independence of Supreme Court, independence of judiciary, and independence of judiciary is basic structure, right? Earlier the collegium system became operative again. So this was an attempt, 99th Constitutional Amendment Act was an attempt to replace collegium system. And why? The reason was that collegium was or is opaque body, opaque mechanism. Lack of transparency is there. Qualification, you need to be citizen of India, obviously. He should have a judicial office in the territory of India for 10 years, or he should have been advocate of a high court or high courts in succession for 10 years. These are OR's part, okay. Either you can have this combination or you can have this combination. Oath is given by governor. Please remember, appointment is being done by president, but oath is being given by governor. Tenure, there is no fixed tenure, okay. But what is age? Age, maximum age is 62 years. Now there can be a question from here. What if we have some discussion on the age of that concerned judge of high court or a person who is going to be appointed as judge of high court? In this case, any question regarding his age to be decided by president after consultation with Chief Justice of India, and the decision of the president is final. It means UPSC can play with you by saying, in case of confusion or dispute with respect to age of a concerned candidate for the position of judge of high court, Supreme Court's decision will be final, or Supreme Court will take this up, but reality is president, okay. And it is saying president is going to consult CGI, okay. It's not like a formal case is going to be leveled regarding this. He can resign his office by writing to the president. Now, oath was given by governor, okay, but resignation is being given to president, because president is the one who appointed. What UPSC is going to play with you? They are going to use CJ of High Court, and many students would think, oh, since High Court judge and senior of High Court judge is Chief Justice of High Court, it means he or she should give resignation to Chief Justice. But that's not true. That is going to be a trap. He can be removed from office by the president on the recommendation of parliament. There's a process to that we are going to discuss. He vacates his office, judge of Supreme Court, or means the way Supreme Court judges are removed is the same way for removal of High Court judges. Removal of judges. So process of removal is elaborated in Judges Inquiry Act 1968. For that, a removal motion signed by 100 members in case of Lok Sabha and 50 members in case of Raj Sabha. We discussed the same in case of removal of Supreme Court judges. Same is the process. Then they are going to present this before Speaker in case of Lok Sabha, Chairman in case of Raj Sabha. Now Speaker or Chairman may admit it or may decline it. If they admit, then there are going to be an inquiry committee and 3-member inquiry committee. And who is going to be part of this inquiry committee? There can be a question. Chief Justice of India or Judge of Supreme Court. Chief Justice of India or Judge of Supreme Court. What UPSC is going to play with you, they can use the word Chief Justice or Senior Most Judge of Supreme Court. But Senior Most Judge is not there. Or Judge of Supreme Court. And some of you might say, sir, why you are playing on these intricacies? Yes, because there is a logic behind it. Why the word senior was not used here? Because same kind of setup is used when we talk about removal of Supreme Court judge. Okay. And consider a Supreme Court judge is quite close to the senior most judge or CGI. Now in this case, don't you think this will be a conflict of interest? If everyone knows that they are relative, right, or they have some common link. So on this basis, that particular person, CGI would say, okay, I am not going to be part of inquiry committee since I have common connection. Senior most judge would say, okay, I am having common connection. So that is why the scope was Judge of Supreme Court, so that other judge can actually take up this responsibility. Okay. A Chief Justice of High Court or distinguished jurist. So you need to remember one person from Supreme Court, either CGI or Judge of Supreme Court. Second is Chief Justice of that High Court, Chief Justice of High Court, and distinguished jurist, Chief Justice of High Court. Okay, not necessarily that High Court. That is also need to be remembered. Please remember. If committee finds the judge guilty of misbehavior, now tell me, if committee found, yes, this person has committed this particular misbehavior. Now tell me, the decision of this committee is going to be final on this house, that now it is mandatory that person is going to be removed from Judge of High Court position, or it is not mandatory? Answer is not mandatory, because if it is mandatory, then why would you have a voting by special majority? Then there is no point of having voting if it is mandatory just after the recommendation of this 3-member committee, right? You should think on these depth. After the motion is passed by each house by special majority, then it is presented before Honorable President, and when President signs, it stands removed. The President passes an order for removing the judge. Clear? Now transfer of judges. So President can transfer a judge from one High Court to another. Okay, President is appointing, President is transferring High Court judges. Please remember. In third judge's case 1998, Supreme Court opined that in case of transfer of High Court judges, Chief Justice of India should consult, in addition to collegium of 4 senior most judges of the Supreme Court, Chief Justice of the 2 High Courts. What does it mean? It means Chief Justice of India along with 4 senior most judges is going to consult 2 High Court judges, High Court Chief Justices, who one from where you are transferring this High Court judge, and other Chief Justice should be in whose High Court you are transferring this judge. Okay, so it means 4 plus 1 5 and 2 7. Clear? Acting Chief Justice. So President can appoint a judge as acting Chief Justice. So what is the meaning of acting? It means present Chief Justice is not in position to work. Office of Chief Justice of the High Court is vacant. Chief Justice of the High Court is temporarily absent. Chief Justice of High Court is unable to perform his duties. So President can appoint qualified person as additional judges of a High Court or a temporary period not exceeding 2 years. So not exceeding 2 years is also a clause there. Now independence of High Court means, do we have some provisions which shows that yes, independence is maintained? Yes. For example, mode of appointment, collegium system is there, right? Security of tenure 62 years, right? And you can be removed only by a process of Parliament. Please remember, removal of High Court judge cannot be done by state legislature or state government. Okay, CM, MLAs, they don't have any role. Clear? Fixed service conditions, expenses charged on consulate fund, charged. It means they are not going to take up for vote again and again in the budget. Conduct of judges cannot be discussed in the House until and unless there is a removal motion in place. Power to punish for its contempt. Its jurisdiction cannot be curtailed. You cannot curtail the power. Freedom to appoint staff. For example, State Public Service Commission work in close coordination with State High Court when it comes to staff hiring. Separation from executive. Ban on practice after retirement. Means judges cannot practice as a lawyer in court after retirement. Now coming to the other important part, jurisdictions. Now recollect what we discussed in original jurisdiction. What does it mean? It means that in these areas a person can directly go to this level of court, right? So original jurisdiction, power of High Court to hear disputes in first instance, not way of appeal, means cases which can directly go at the level of High Court. Then these cases or these areas will come under original jurisdiction of High Court. Okay, it extends to what kind of matters? For example, will, marriage, divorce, company law, contempt court, dispute relating to election of members of Parliament, state legislature. Please remember, members of Parliament, right? Dispute related to this also comes under original jurisdiction of High Court. There can be a question. Revenue matter, fundamental rights, for example, Article 226. You can directly go to High Court. Cases to be transferred from subordinate court involving interpretation of Constitution, means interpretation of Constitution. You know, there are just 2 levels of judiciary, higher judiciary, you can say, High Court and Supreme Court, who can interpret Constitution, right? So these are original jurisdiction. Now writ jurisdiction. We discussed these writs when we discussed Article 32, the meaning of these writs, and I told you there that as per Article 226, High Court can issue these writs for protection of fundamental right as well as legal rights. But when it comes to Supreme Court, under Article 32, Supreme Court can issue these writs just for fundamental rights. Okay. So this is what we have discussed here. So writ jurisdiction of the High Court is wider. Okay, because it also includes protection of legal rights. Okay, I hope it is clear to you now. Now in Chandra Kumar case, Supreme Court said writ jurisdiction of Supreme Court as well as High Court are part of basic structure of Indian Constitution. So please remember the case as well. Chandra Kumar, writ jurisdiction. Okay, for that you should remember, make some mnemonic, logic, means your own logic, a story. because these are the high probability questions. Now appellate jurisdiction, it simply means by way of appeal you can reach to High Court. For example, primary court of appeal is High Court, means High Court works as primarily as court of appeal, because from subordinate court, district court, matters take up at High Court for appeal. It hears appeals against the judgments of subordinate court in its territorial jurisdiction. Means if there is a UP High Court, it is not going to take up appeal from district court of Madhya Pradesh, right? It has appellate jurisdiction in both civil and criminal matter. Hence, the appellate jurisdiction of High Court is wider than the original jurisdiction. Now, civil matters. Civil matters means we are talking about matters related to land disputes, matters related to tax revenue, family disputes. So, first appeal from the orders and judgments of district courts, they can come as appeal before High Court if the amount exceeds a stipulated limit. Second appeal from the orders and judgments of the district court when there is a question of law, means you need interpretation from High Court on this particular law. So it means both the cases, whether it is amount, whether it is about interpretation of that particular law, these cases can come at the level of High Court as a way of appeal. Calcutta, Bombay, Madras High Courts have provisions of intra-court appeal. Please remember it. First of all, what is intra-court appeal? It means your case was taken up at the level of Calcutta High Court. Okay, judgment has been given, but you're not satisfied. So you should not necessarily think about Supreme Court. You can actually go for appeal within Calcutta High Court. This is called intra-court appeal. Means within court you can appeal. Okay. Appeal from decisions of the administrative and other tribunals lie to the divisional bench of State High Court. It means from tribunals as well. Appellate jurisdiction of High Court extends there. In 1997, Supreme Court said that tribunals are subjected to writ jurisdiction of High Court. Means High Court can issue writs against tribunals. Consequently, it is not possible for the aggrieved person to approach Supreme Court directly against a decision of the tribunal. Now, my question to you here is, can you tell me what about appeal against a award or judgment of water dispute tribunal, interstate water dispute tribunal? So you have to answer this in comments. I am simply asking, this particular statement is saying when it comes to decision of a tribunal, you cannot directly go to Supreme Court. First you have to go to High Court. I am asking, can this case or this particular notion be applied for the case of interstate water dispute tribunal? Okay, so think about it. Water dispute tribunal, search about it, let me know in comments, because these are the areas where UPSC is going to play. Now, criminal matters. Appeals from judgments of Sessions Court, Additional Session Court lie in the High Court if sentences of imprisonment are more than 7 years. You simply need to remember two things when it comes to appeal in case of High Court. Number one is 7 years and more. If sentence is 7 years or more, then it can be taken up at the level of High Court as appeal, right? Second is, in case of death sentence by a district court, district session court, no matter that person has appealed before High Court or not, High Court is going to take up this matter because it is about death sentence. Okay, death sentence cannot be executed without High Court taking up this matter. So in death sentence, please remember, in some cases specified in various provisions, Criminal Procedure Code, the appeal from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate and other Magistrate Judicial to the High Court. Means in certain cases they can directly go up as appeal to High Court. Now comes the supervisory jurisdiction. What does it mean? Supervising. What is the meaning of supervising? It means you are taking care of the rules and whether they are being followed on regular basis in these lower courts, right? So it means High Court has the supervisory jurisdiction over district court, subordinate court, not Supreme Court. Supreme Court is not having supervisory jurisdiction. Some students are going to get confused. Like it is said, the judgment of Supreme Court is applicable on all courts. Judgment is one thing, but when it comes to supervision, it has two components, administrative as well as judicial. Means staff related function, and these functions, general rule, prescribed forms, book entries, accounts, how many court fees you are taking, in what way you are taking. These matters are also under the control of High Court of that particular state. The power of superintendence of High Court, it extends to all courts, tribunals, whether they are subject to the appellate jurisdiction of High Court or not. This question can be asked. means supervisory jurisdiction is applicable on all tribunals in territorial jurisdiction of that high court. Okay. It covers not only administrative superintendence as well as judicial, means the kind of decisions you are taking, the speed with which you are actually taking up the cases. So judicial part is also going to be considered here. Revisional jurisdiction means judgment can be revised, right? It can also take suo motu action, means on its own. However, the power does not vest in the High Court with any unlimited authority over the subordinate courts and tribunal. It is limited to access of jurisdiction, means in what cases High Court can intervene in the functioning of subordinate court. If there is access of jurisdiction, it means you are not given that much power, but you are exercising power beyond your ambit. Then High Court can supervise. Gross violation of natural justice, error of law, disregard to the law of superior courts, means High Court has said something and High Court is a court of record, but you are not giving adherence to the what High Court has said on this particular matter. Perverse findings, manifest of injustice. So in these cases, High Court can intervene in functioning of subordinate court. Now, control over subordinate court. It is consulted by governor in the matters of appointment, posting. For example, I told you, in case of transfer, appointment, a State Public Service Commission is going to conduct the exam, interviews, but in close coordination with State High Court. And who is going to appoint? Their governor is going to appoint. I am talking about subordinate courts. Okay. It deals with the matters of posting, promotion, grant, leave, transfer, discipline of the members of the judicial service of the state, other than district judges. It can withdraw a case pending in a subordinate court if it involves substantial question of law require interpretation. So because district court cannot interpret constitution, if it seems that interpretation is constitution is needed, then High Court can take up that case from district court. It can either dispose of the case or determine the question of law. Dispose means case is quashed, or it can take up the case. Law is binding on all subordinate courts because it is part of supervisory jurisdiction. When I say court of record, what does it mean? It means perpetual memory and testimony. In your judgments, you are going to quote this. These records are admitted to the evidential value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedent, legal references. Means on this basis, you are going to rule the judgment. It has power to punish the contempt of court either with simple imprisonment, fine, or both. Expression of contempt of court is not mentioned in our constitution. Please remember that. There can be a question from here. We have a law, Contempt of Court Act 1971, which elaborate on the definition of contempt and what can happen. Under the contempt of court may be civil or criminal. Civil means willful disobedience to any judgment, order, writ, or other processes of the court, willful breach of any undertaking given to the court. That would be considered as civil contempt. Now, power of judicial review. We discussed in Supreme Court as well, right? Judicial review, Article 12, right? Article 13. Article 13 we talked about, and Article 32. So, judicial review is the power of High Court to examine constitutionality of the legal or executive actions. The phrase judicial review is nowhere mentioned in Indian Constitution, but Article 13 and Article 226 in case of High Court, it gives power to High Court to review whether legislative or executive action. Now, in what cases the judicial review can happen? One is fundamental right. If some law or some executive action is taking away your fundamental right, judicial review can actually work. Second is outside the purview. It means any authority has taken some action which is outside its power. How can this happen? Judicial review can apply. Or these provisions or these laws which are being made or some executive action, this is against some constitutional provision. In this case also, direct judicial review can be applied. So these three are the areas which you should remember when judicial review is going to be applied. Direct question can be asked. So during Indira Gandhiji's time, 42nd Amendment Act, it actually limited the power of judicial review of High Court, saying that judicial review is going to be applicable just to state laws, right? But after this 43rd Amendment Act, it restored the original position. What does it mean? There can be a question. Meaning is that judicial review power of High Court is applicable also on central law. Please remember it. Now, which of the following is the oldest High Court in India? Calcutta High Court. That's a factual question. Now, Article 213 provides that there shall be a high court for each state. Tell me, do you think that statement is true? Now, some of you might be thinking, sir, we don't remember the articles. What now? My friends, sometimes some articles are regularly in news and UPSC wants to check whether you are aware about them or not. It's not like UPSC wants you to cram the whole constitution article wise. Article 213 is related to ordinance making power of governor, right? And Article 123 is about ordinance making power of president, right? So how can this statement be true then? It's false. Now, judges of High Court are appointed by President, you just got to know. Under Article 226, it has the power to issue certain writs. We discussed it. As per provisions of the Constitution of India, Common High Court can be established for 2 or more states. It is right. By which Constitutional Amendment Act? We discussed 7th. Right? So, answer would be 234. C. Right? So, I hope now this part is clear to you. See you in the next video. Till then, keep learning, keep growing. If you find any question which is troubling you, you can shoot me a message on my personal Insta, shashank.powerbeing. I'll be more than happy to help you out. This PDF is going to be available in Shashank Tyagi for you Telegram group. See you.